Hello, everyone. We're just going to take a minute and wait for everyone to get on. All right, looks like we got the majority of everyone on. Just want to say hello and welcome to our webinar on the Southeast Texas Area Reliability Project, Landowner Rights and Condemnation Explained. My name is Claire Elliott and I oversee marketing for Braun Gresham. Our attorneys leading today's presentation are Patrick L. Reznik and Carly Barton. At Braun Gresham, we represent clients across the entire state of Texas and exclusively represent landowners. The state of Texas is our map that represents all of the practice areas that we have here at our firm. We have 15 attorneys on our team and we represent clients in all facets of land ownership. As you can see on our map here, from estate planning to renewable energy, conservation easements, and of course, condemnation. Before I turn it over to Patrick and Carly to get us started today, I'm going to give an overview on how to submit your questions during today's presentation. To access the Q&A, you'll scroll your cursor over the Zoom screen and you'll see a toolbar pop up at the top or bottom of your screen. On the toolbar, you will see a Q&A symbol. When you click that, it will open a separate pop-up box where you can type your questions directly. No one can see your pop-up box, no one can see the questions you submit except for our moderators. We'll be answering questions throughout today's presentation, so please feel free to pop them in at any time. After today's presentation, we'll be following up with a recording and an email to connect you with our team. Thank you all for taking the time to join us today. Now I'll turn it over to Patrick to get started on today's presentation.
Well, good afternoon, everyone. My name is Patrick Reznik. I'm an attorney with Braun Gresham along with Carly Barton. Just a little bit about myself. I grew up in Texas on a farm and ranch. I'm a Texas landowner. I graduated from Texas Tech University and have worked all over the state. And I really love what I do. And as part of Braun Gresham, we represent landowners around the state. Carly and I are going to be focusing in on the condemnation part of our practice, and that's where we only represent landowners in proceedings where eminent domain authorities, whether it's a pipeline or a transmission line in this case, or TxDOT or a county road or a city project, any authority that has eminent domain that can condemn your property. We'll talk a lot about the technical parts about that. But again, we only represent landowners. So I really want to focus in on that we only represent landowners around the state of Texas. So today's presentation is going to focus on the landowner who is being condemned by this new 500 kilovolt transmission line. And we want to empower you to understand what your rights are as a landowner, why you can't prevent this from happening because they do have the eminent domain authority to condemn and take your land. And I say take, and that's what they're doing for an easement. They're not taking the land for to own or in fee, as we call it. It will be for an easement. And we'll talk about what that easement is and what the rights are being taken away from you and what your rights are as a particular landowner. So, Carly, why don't you introduce yourself?
Sure. My name is Carly Barton. I'm an attorney here at Braun Gresham, and I'm also part of the condemnation team. Patrick and I are the two attorneys. We also have some wonderful staff. Audrey Banner is our paralegal. April Soloway is our executive assistant. So together we are the people at Braun Gresham who handle the condemnation matters and make sure that we are advocating for your land and on behalf of landowners throughout the state of Texas. I'm going to talk to you a little bit about first.
Let me just say one thing. I know each of you have got some sort of communication from us, whether it's a letter or a postcard. I know there's concerns among landowners about the information they're getting. And quite frankly, what we're seeing happening is that there's a lot of companies from out of state who are soliciting information from landowners about these particular projects because they are really, really big projects. And I want to just say, for our firm representing landowners, this is for information for you, whether you retain us or not, or we hire us or not. We want you to feel empowered as a landowner because that's what we do, is help landowners around the state. There are companies that are sending solicitation letters from all parts of the United States. I just saw one from New Jersey recently, one from Ohio recently. So if you would please separate what we're trying to do from those other companies who are out there who are not part of Texas and part of the Texas community, I would appreciate that. So thank you, Carly.
So I'm going to kick us off and kind of to piggyback off of what Patrick said. We're here, a lot of this is about education so that you are empowered as a landowner to understand what is condemnation, what is eminent domain, what are my rights, what are the rights and responsibilities of the condemning authority, and how can you protect yourself and make sure that you understand the process. So the best way to describe the difference between condemnation and eminent domain is the power or the right of the government or private party, which is acting under a government's authority, to take your land for a public purpose or a public use. So eminent domain is the power, and then condemnation is the process in which that power, that eminent domain power, occurs and how land is acquired from landowners. So why should that matter? And these powers are conferred through a couple of documents, right? First, the United States Constitution. Second, the Texas Constitution. Both of those documents have eminent domain authorities for the government in there. But in Texas, we follow the Texas Property Code, Chapter 21, which will have each of the rules and the procedures that a landowner can expect to go through for the condemnation process. But why should it matter to you? There are many reasons you need to be educated about condemnation cases or potential projects in your area, because many times a condemnation project means there's going to be a potential loss of property. Also, you want to make sure that you are getting fairly compensated for when you lose that property right. As Patrick mentioned, since we're talking about the Southeast Texas Reliability Project, these are transmission lines, so they are going to be easements. So you still have limited use of your property underneath the power lines. It's very, very restricted. However, so you will still own the land underneath those transmission lines. And so you'll have that loss of property. You want to make sure you're getting fairly compensated because that's what the law dictates. You are supposed to be fairly compensated. And many times those initial offer letters you're getting from the condemning authorities or the utility companies are quite low. You also want to be paying attention because there is quite a lot of rapid growth in Texas. So what we're seeing throughout the state is that Texas in general is moving towards larger transmission lines like this 500 kilovolt line for Entergy. Up until this point, most of the big transmission lines that you are seeing in Texas are just 345 kilovolt lines. In East Texas, we're seeing 500 kilovolt lines. In West Texas, we are seeing 765 kilovolt lines. And there will be even some 765 kilovolt lines that will be happening in the East Texas region as well a few years down the road. So that rapid growth, the need for power, the fact that Texas, really thrives on its energy industry and that portion of the economy, we're seeing that with the infrastructure that is needed to have that energy dominance. Also, I want to make sure that you understand the process, what to expect when you get that first contact from a condemning authority, that the resources available to you, that you seek legal advice and professional advice at the right time and when it's the best time to do that. And also that that there are educated professionals out there that can help you, such as the right appraisers who can really get into the details about how much your land is worth and what does that adequate compensation look like. We touched on this a little bit, but that condemnation procedure does go through Chapter 21 of the Texas Property Code. And so private property can only be taken by a government entity or a private entity that is authorized to do so under the law. And when we're talking about the condemnation procedure and Entergy's ability to come and take this easement from your land, what happened in this particular case is that the transmission lines go through a transmission line routing procedure through the Public Utility Commission of Texas. So at some point, you should have received a couple years ago, a year and a half ago or so, you should have received a notification that Entergy was going to be applying to amend its certificate of convenience and necessity through the Public Utility Commission to select a route for this transmission line. And through that process, you can, as a impacted landowner, or if you have a habitable structure within 500 feet of the center line, you can be a part of that process. And so, but really what that does and what that transmission line routing process does is at the end of all of those proceedings, the Public Utility Commission submits a final order. And that final order is what gives Entergy the condemning authority to come in and take your land for this easement. That is the authority from the government through the Public Utility Commission to come in and take. And so now we're to the part, we know that they have condemning authority, but now we're to the part that we've got to make sure that the landowner is getting adequate compensation, and that is not just damages to the easement itself, but maybe damages of the remaining property's market value and other things along the way. So also, you also receive, if you've been in contact with Entergy or received any kind of correspondence with them, there is a document, there's the Landowner Bill of Rights. This is a nice synopsis of the rights that landowners have under Chapter 21 of the Texas Property Code that you can look at, and a good overview of what you can expect, or so that you're a little more comfortable with what is going to be happening. Obviously, this is just the beginning, right? These are kind of the bare bones of your rights, but we want to make sure that landowners are aware of what's going on, what they can do if you don't like the offer that you're getting, if you don't like that amount of money or the terms of the easement, that you can fight back and that you can do things to protect your land besides just signing the initial offer that you receive from the condemning authority. And so Patrick now is going to talk to us about what is adequate compensation and how is that calculated, particularly in a transmission line case.
Now, we have multiple clients on this particular project who are receiving mainly letters to survey their properties. And that's part of the initial part of the process. And we'll talk a little bit more about that after we talk about the adequate compensation. But want to emphasize, if you're getting any sort of letters asking to survey, our clients are not signing those survey request forms. We have a special form that gives landowners far greater protections and limitations on time. And we'll talk about that a little bit more, but I wanted to know that that's what's happening right now. We don't have any clients who received a offer for compensation, and that's going to be the initial offer. But as far as what adequate compensation is, that's under again, the Constitution of the U.S. and Texas. And basically, the Supreme Court of Texas says, what is the value of your land before this new infrastructure, before this transmission line? And what is the value of your property afterwards? And the difference in that is the adequate compensation. We don't know what Entergy is going to do, or what their appraisers are going to do, or what they're going to be offering. What we have seen historically, and I can only talk about, the last 10, 15, 20 years we've been doing this, is on transmission line cases, most of the time the appraisers don't see that there's actually damages to the rest of your property. They just give a valuation for the land that's being taken for the easement. This image is a good example. If you have property that is rectangular in shape, the part taken is the transmission line easement. That's going to be a 200-foot or so easement in this particular case. And what's left is your remaining portion of the property. So what happens is that you're offered an amount for the part taken. This is not TxDOT taking your land for a new road. It's for an easement. You will still own the property, and you still have rights to use the property, but it's limited on what you can do on the property. And we'll talk more about the easement negotiations that we'll also provide to our clients. But the valuation may be, for example, if the property is worth, let's just say, an even number of $10,000 an acre, and the acreage that's being taken for the easement, the utility company may offer you somewhere between 75% and 95% of the value of that. But they may not see that there's damages to the remainder. And a lot of the big fight is about, well, listen, I don't have any transmission line on my property. Now I have one on my property. Now my house, my backyard is looking at this transmission line. There's an aesthetic component to that. All the trees in this area will be taken out. There's loss of value to my whole property as a result of that. So there's remainder damages and there's damages for the part that is taken. That total compensation essentially is what is the value again of the whole property without this new transmission line and what the property's value is with the transmission line.
Patrick, we have a question from the group. It says, I wasn't notified until a phone call this year. The paperwork I got from Entergy had PUC hearing data in which they told the PUC that all parties had been notified. I was not. Is there any recourse for not being notified until this year?
Carly, why don't you take that? Because that goes back to the notification on the routing process.
Sure.
And the short answer is no, but why don't you take that, Carly?
Yes. So the list for notification that you get are based on your central appraisal district's property tax records. So that is what's required for them to attest to notice. So if you have the wrong address or a different address, or maybe you even have like a property tax consultant that does your property tax protests, sometimes those addresses do not match up. Sometimes they're old addresses, or sometimes if you've purchased a property in a short amount of time, the CAD hasn't updated their data either. Patrick is right. The short of it is that you do not have any recourse, unfortunately, but that is sometimes why it happens in that circumstance.
And thank you for that question. And please present more questions and we'll answer them along the way. This is not a transmission line example, but it's just a good example about how we look at these cases and how we look at damages. This is an example that TxDOT was taking some land. They were taking a building from our client, and we looked at the value of the land and we looked at what the value of the improvements. And so again, in the green is what the value of the whole property was with improvements. And then once TxDOT came in and they took the land, they took the building, we look at what the value of the property is without those improvements and with what's left on the remaining portion of the property. And we came up with a valuation of $3.6 million. That was a couple more $1 million than what TxDOT's appraisers looked at. So this is a simple example that what we do is we look at what Entergy in this case is going to be appraising the value of the land. The value of the land may be low. Maybe it's going to be close to what we think the value is, but we look at the value of the land per acre. Then we also look at the value of what's been taken, and then we look at the remainder damages. And we give a good analysis of what your offer is under the law of the Texas Supreme Court and also the Texas Property Code, Chapter 21, to determine whether we believe that the offer is adequate compensation under the laws of the state of Texas and the U.S. Constitution. It rarely is rarely in our opinion, is the value adequate. And then we have experts, and we'll talk a little bit more about that from an appraisal standpoint that can analyze it and determine what the damages are and what we believe you should be paid.
So now that we've talked about adequate compensation, the next part is going to be about the stages of condemnation. Again, what to expect when you are going to be condemned. And so the first one we're going to get to is project planning and the public use determination. So typically this might be by the government, right? TxDOT coming in and saying, we want to build a road here and expanding it. In this case, it was that application that Entergy filed through the Public Utility Commission to amend their certificate of convenience and necessity. And so they have to show that there is a need for these transmission lines, that it promotes grid reliability and to move power, those important things. On top of that, the route is meeting some routing criteria. And so that project planning and that public use determination went through, that all happened at the Public Utility Commission routing stage for this particular project. But the second stage of condemnation is an initial contact and offer. So currently, the Entergy right-of-way agents are reaching out to impacted landowners, making that initial contact, trying to get your permission to get onto their property, onto your property. They need to do surveying, right, to determine the exact location of where that easement will be, that they can have the correct description of that, the legal description, but also they can also be doing geotechnical studies to make sure that the footings and the construction of it, that they're designing that correctly with the soils that are on your property. And so that initial contact is occurring right now. As Patrick mentioned, this is a good time when we step in as the lawyers to restrict how much Entergy will be on your property in terms of time, notification, protections for you. For those who have received that contact from Entergy, right? It's typically just a blank page. You fill in a little bit of questions, answer a few things, but it doesn't have anything else on there. So many times we enter into a right of entry agreement with the condemning authority so that they will, again, not just have unfettered access to your land. So that initial contact is occurring right now. And then after those site visits are conducted, they get their surveys, they have their geotech teams go out there. Sometimes even appraisers will visit the property as well. Then you'll receive an initial offer letter from the company. And so that is really the first thing where you will get an idea of how the Entergy is looking at your property in terms of what is adequate compensation. And many times, this step in the condemnation process is where people turn to lawyers so that they can get a right of entry agreement, so that they understand what is going on. And also, I think a lot of times you've got pushy right-of-way agents who are just bothering you all the time. I don't think the ones in this project have been particularly bad, or at least the ones we've worked with thus far. But as the offers come in and as the negotiations heat up, that pressure really starts to build. And sometimes it can be very overwhelming because there's a timeline, there's lots of pressure, they're trying to get you to sign. So this is always a good time to reach out to a lawyer to talk about what are your rights and how you can protect them the best. The third stage is a bona fide offer in negotiation. So that offer means that it's a term of art. We find it in Chapter 21 of the Texas Property Code, but it has to be a fair attempt to negotiate in good faith. Now, I think that there is quite a big difference most of the time with the landowner's belief about what their property is worth versus what the condemning authority believes what their property is worth. And so whether that's a fair attempt to negotiate in good faith, I think probably a lot of our clients would say it's not, but they do have to make a real offer that they will back up and that they would accept if you accepted those terms. And at this point, you can accept it, you can reject it, and then you can also you can negotiate with them to try and come to a better agreement for yourself. Importantly, though, this is not just about compensation. While that is a very big part of what a condemnation case is, there's also easement terms. And the easement that you get in that initial offer many times can be negotiated. You can protect your land more. You can add in certain things to that easement so that you are better protected and that Entergy can't just do whatever they want
When Carly was talking about the first stages of condemnation, the initial offer letter oftentimes will say a 30 days, sometimes it'll say 33 days, and you have to respond by that time. That is a 30-day offer letter that's required by the Texas Property Code. They require to give you 30 days to respond. And if you don't, there's no consequence to that other than you haven't responded. They're going to send out the final offer. At some point in time, they will have sent an appraisal. Sometimes they do it with the initial offer, sometimes they do it with the final offer. For it to be a bona fide offer, you have to get an appraisal from an appraisal company that's licensed in the state of Texas to give an opinion on valuation. Appraisal methodology is an art form. It's not an exact science. So when we look at it, we often see those appraisals are flawed, that the land values are too low. They don't take into consequence the damages to the rest of the property. And each transmission line that crosses a property is a different impact. If it goes to the middle of the property, that's a different impact than if it goes along the edge of the property. If it goes right in front of your home, whatever that home is, whether it's a $2 million home or a condominium or bardominium, it could be, the impacts are different. So we look at that appraisal, and then when the final offer comes in, you only have 14 days. That's again statutory. They have to give you at least 14 days. 14 days before what? 14 days before they go to the next phase, and that's filing a petition in the court in the county that handles the condemnation cases. So if you don't respond to the 14-day offer letter, that's okay. But we really should be talking with you at that point in time to give you the opinion on whether the offer is fair or not. Because if you don't respond, then they file the petition and condemnation. Yes, you will be sued. I've had clients in the past who are very sophisticated clients who are developers, this, that, the other, and they get that petition and I've just been sued. Well, of course you've been sued because that's part of the condemnation process. Because ultimately the condemning authority, Entergy in this case, wants to be able to build this transmission line. They don't have the right, other than the survey, to do anything other than give you these offers until they have those rights. And the way they get those rights is filing the petition and condemnation and going through the next stages of the condemnation process. So if you go through that, we just tell our clients, don't worry about it. It's still part of it. Part of what we try to do for our clients, and I hope we do it very well, and I think we do, is taking the stress away of the pressure of what's happening, because it doesn't feel good to have to go through this process. It doesn't feel good to be sued. And there's a panic mode that often happens with our clients. For we try to take that away from you and to guide you through the process, to let you know it's okay. And we do have to communicate with you. We do have to start making decisions. One decision that we have to start making at this point in time is, do we hire our own appraisal? So if we hire our own appraiser to give an appraisal, there's a cost, of course, associated with that. We have some very good appraisers around the state of Texas who do very good work looking at the value of the land, looking at the damages to the whole property as a result of these transmission lines. This is the first of a 500 kilovolt line, so there's going to be some new information that we're going to have to gather as far as the long-term impacts to property owners, because once this transmission line is built, it'll be there for a long, long time. These new lines are really built to last for 100 years, to withstand hurricanes, to withstand high winds and tornadoes and all sorts of storms. And it will be there long after we're gone and your ancestors have this particular property. So this is a one-time payment, and it's an easement that has to be negotiated, that's going to go and be part of the deed records, that's going to be run with the land. So the next owner will actually be subject to that particular easement once it's recorded.
After the petition and condemnation is filed, typically also what happens is the court where it's filed will appoint some special commissioners. These are not your county commissioners, but they are resident landowners in your county. And they will sit on a panel and have a special commissioner's hearing. And at that hearing, each side can present evidence about what they believe the adequate compensation is under the law. So Entergy will have their appraiser, they typically have a project manager, and they will testify as to what they think the adequate compensation is and what this project is about. But you as a landowner also get the opportunity to testify and have your own appraiser there to talk about what you think is an adequate compensation. And so that's a really interesting and unique area. There's not anything quite like it in the law to have just really these people who are appointed by the court to sit on a panel to determine what your adequate compensation is. And so after that hearing, and it's not in front of a judge, it can be quite casual, but after that, the special commissioners will issue their award. And that award is what they think is that just compensation. And from there, each side can object to that award, right? If the landowner believes it's too little, they can object. If Entergy thinks it's too much, they can object. And after that objection is filed, then the whole case gets kind of kicked back into the trial court, where you can have a jury trial on what is that adequate compensation. And you can have 6 or 12 jury of your peers determine what that is. And so there are some unique procedural aspects to these cases that don't currently happen in most cases. And I'm going to read these questions real quick and see if we can answer them. So Patrick, it says, based on previous experience, it seems that offer being made varies significantly based simply on the size of the tract of the easement that is being taken from. For example, say tract 1 consists of 20 acres, which is valued at $30,000 per acre, and tract 2 consists of 1,000 acres valued at $5,000 per acre. Let's say the easement is let's say that the easement that is taken is the same size, say 1 acre and location along the boundary from each tract, but the offer is widely different, 30,000 versus 5,000, just based on the size of the tract that the easement is taken from. In essence, if you own a large tract, you receive less. I've seen some owners subdivide their tracts prior to taking to decrease the size of their tract. What's the best method to handle this?
It's a very unique question to particular property. And so I can't give a generalization other than what we do is we look at what's called the highest and best use of the property. This area is really interesting because there are piney woods, people have timberland, they have ag valuations for timber to keep the taxes low, but there's also developing areas that are very close by. So we look at what's the highest and best use of the property. It's not what the property is being used now. It may be in timber, but there may be subdivisions that are happening right next door. There may be a hard corner, for example. There may be an intersection of two county roads. There may be a opportunity, for example, to have a convenience store on a particular corner. We look at what are called economic units. And I think that's part of what the question is asked is that we look at the whole property, we look at where the transmission line is going to go and what's being taken, and then we look at what is the highest and best use of the property. If the highest and best use is simply for agricultural land, it's for raising cattle, we may not have an economic unit. And so we just look at the whole property and the value of the whole property, and then the value of what's been taking, and then the value of the diminution for the rest of the remaining portion of the property. But if we can divide the property in separate economic units, because one property may have an opportunity for a future development, let's say its highest and best uses for future residential development, then we could look at platting that particular property for a subdivision, and then look how the transmission line is taking away the value of that potential development. One thing under the law is it can't be speculative. And so I can't just say, well, one day this property is going to be used for high density residential development or a golf course or industrial park or whatever. It has to be the highest and best use now at the time that the transmission line is being placed on the particular property. And so we look at all those different valuations, and that's where the appraisal methodology can be very interesting and creative, but ultimately it has to be based on the marketplace. Is what is the market out there demanding for the value of particular properties? I know that's a long-winded answer to your question. It is a complicated question in the sense that it has to be, we have to look at the property exactly what the highest and best use is for that particular property, and then how we look at the damage model. And that's where our expertise comes in to play, as well as our appraisals and the appraisal methodology and the appraisers that we use. And so, Carly, I think there was a second question.
There was a question about, can we find out exactly where the lines are going to be constructed? I sent you a link to the interactive map so you can look up your particular property, but we're going to have some bigger maps here in this presentation and just right about now. So
the short answer is yes, we can help you find what the Public Utility Commission approved. Now, they're surveying right now, so the exact location is not going to be until after we get the surveys. But one thing we try to do with our particular clients is, can we make some modifications about where that transmission line is going to go? And the Public Utility Commission issues an order that, as Carly mentioned, allows Entergy, in this case, to have eminent domain authority to condemn. But it also has a provision in the order that says, work with the landowners, essentially, see if there's minor deviations that could be happen in order to, for example, not take a water well out of existence or something of that nature. So thanks, Carly.
yeah. So this is just a quick overview of the project and where we are right now. So the Southeast Texas Area Reliability Project that Entergy put out there, it's a 500 kilovolt transmission line. The picture on the left is a kind of rendering of what to expect these structures to look like, that the lattice steel structures to look like. If you can see, there's a little bit of measurements in there, right? You can see that they are about 100 feet tall, and the easement width that they're going to need to construct these is 225 feet. So you will be getting a 225 feet clear cut straight through your land. And then we've talked a little bit about it, right? Current status is that they are surveying. Right-of-way agents are reaching out to get permission to get on your property so that they can start these surveying activities. And then right-of-way acquisition, you're in it right now. So right now through April of 2027, and that would be at the very end of it. They're really trying, they would much prefer to get these done as quickly as possible. So they're trying to get this line energized as fast as possible, which means they've got to acquire the right of way so then they can build it and then they can energize that line. And so this 2027 deadline will creep up on us very quickly if you're not too careful. And so this is where we are at this point. And so let's see. The next question we have is, considering we're being contacted by servers desiring to survey our land, and when do you anticipate we will receive our first offer letters?
If you're being requested to survey, again, I want to go back to that survey agreement. We don't recommend that you sign their blanket survey agreement. We have a form that limits it in time, limits in location. They have to notify you, and so that you have some control. Now, they can go to the court if you refuse and get an injunction, and they're going to be allowed to survey. So that's that. But when the offer comes out, it will probably be within 60 days, 30 to 60 days after they survey. Their appraisers are very, very busy, also trying to figure out how to value the line and the damages. We haven't seen one yet, so we don't know exactly what their methodology is going to be and what their approach is going to be. We anticipate that their initial offers may or may not have an appraisal. If their appraisers are not ready, they may go ahead and just do a blanket so much per acre for the 225 foot easement. and put that number out there. It may not have any basis for that particular number or any explanation for that number, but they are under pressure from the state to get this line energized, which requires a taking of the land and building it. So it's a long process. So my best guess is that within 30 days after the survey, you will have some sort of offer. It may not have an appraisal, and it may look like just a blanket number that has no basis for it. Call us and we have a free consultation. We'll help you work through that. But I would expect right now, surveys are starting to happen. Again, 30 to 60 days is my best guess. There's no statutory requirement for that. So again, we're here to help you, guide you through this process, because it is anxiety ridden and uncertain.
So the next slide we're going to look at is an approximate path of this transmission line. This is a very large project, right? It spans multiple counties. So we've got to, I know it's kind of hard to read, but it does start off down here west of 45, just north of Willis. It comes down. Let me see if I can get a good arrow here for us. All right, so it's down here, and this dashed line is what is the path. Those numbers that you see there, those were the various segments that were included. So splits the Sam Houston National Forest, heads up close to Point Blank, and then over there it crosses the Lake Livingston, goes north of Onalaska, Seven Oaks, heads over here to Chester. And then our next slide. I don't know that. And then you can see it coming here again. That's that dashed line north of Holmesneal. There is an interactive map on Entergy's website. That is, you can use satellite imagery and you can see it. But we can also help you pull a map too. I know it's, like I said, it's a very big project, so it can be a little overwhelming with all the maps that are online. So that's the path that the transmission line is taking and what to expect. And then Patrick's going to talk a little bit about our role in this.
And continue to please put questions, and we're going to be wrapping up here in the next 5 or 10 minutes. But we're here to answer any questions that you have, whether it's now, whether it's by email, or whether by a phone call, to help you through this process. But our role really is to guide you through the process to make sure that you're making the best decision that you can. One of the hard parts about this as landowners is that you don't have the right to say no. That's why we're talking about this is not a sale. This is a condemnation. They are taking your land for this easement. Now, again, you still own the property, you still pay taxes on the property, you still can use the property, but you're very limited. Again, you can't build anything on that 225-foot easement. You can run cattle under it, but you can't grow forest under it. It really limits to what you can do. Plus, it just is, quite frankly, just a terrible eyesore on the property, especially when you're out in the middle away from downtown Houston and Memorial Park, where there's so much infrastructure there. People don't notice the transmission lines, but when you're out where you are in these properties and you think you're away from all this infrastructure, pipelines are under the ground, these are above the ground. And so what we work with you on is making sure that your rights are protected, that you get the best opportunity for easement terms, and quite frankly, the best compensation that you can get. We really work hard to relieve the stress that this can be. The right-of-way agents, we don't know exactly how they're going to approach when it comes to the initial offers. Some right-of-way agents are very aggressive. They want to come and have a cup of coffee with you. have the easement document in front of you, sign it, we'll pay you and write you a check now and be done with it. We've actually had some right-of-way agents, not these necessarily, but in the past say, don't talk to a lawyer. All they're going to do is take your money. So don't talk to a lawyer and understand your rights. We're doing what's best for you. Choosing the best and qualified appraiser is really an important, especially if it's a case that's going to be complicated, like the question that we had. There's going to be various economic units. There's going to be different price valuations for the property. We have those experts. Sometimes we use a land planner. Sometimes we use a civil engineer. Sometimes we use other experts to help determine what is the proper compensation. And we have that team of experts that we can provide to you if it's necessary. And then balancing just a decision of whether to go to the special commissioners. And again, those special commissioners are not county commissioners. They're not elected officials. They're just landowners in the state who are supposed to be fair and unbiased to decide the initial compensation at the administrative phase. Once we go through that phase, do we actually want to go to a trial? We help you evaluate the risk, the benefits, the challenges of going to a jury trial if you want a jury to decide the ultimate amount of compensation. Or what is the best time to just say, we need to cut a deal? In Texas, we talk about pigs getting fat and hogs getting slaughtered. I mean, there is a point in time where a decision just has to be made of what is the best deal, what is the best compensation. Now, one of the problems that under the law that exists is that they don't have to necessarily negotiate the best terms of easements. You may have a lot of uniqueness on your property and we'll work hard on the easement terms, but there's two buckets. There's a bucket of money and there's a bucket of the easement terms. We have negotiated with Entergy in the past, both on compensation and both on easement terms. We don't know exactly how flexible they're going to be on their easement terms on this particular project, but we start negotiating the easement at the very beginning of the process to give a sense, because the fewer terms that they give that are beneficial to the landowner, my opinion is the more compensation you ought to get. If you're getting better terms of the easement that are satisfactory to you, then you may be willing to take a little bit money. These are really complicated decisions, and they're going to be a decision that's going to last for forever. And so you want to make the right decision. So our role is to help you ultimately make the right decision.
Right. We'll continue to ask some questions if you have any. And I know someone requested a copy of the map. Happy to provide that to y'all. We can even get specific maps for your property. So I've got one email for a map and we can get you some more. But also we always like to end things. We can answer more questions, but we also like to make sure people are aware. We do have a newsletter, the Texas Land Advocate. When we're talking about trying to be on top of these infrastructure projects, potential condemnations that are happening in your area, we send them out in our newsletter, along with many other issues that landowners across the state of Texas should know about, interesting articles, changes in the law, things of that nature. So we would love it if you signed up. We do not spam you. I think it's one a month, maybe two, depending on how much content we have. So that is a great way to stay on top of things when you're a landowner. It looks like we have another question. It says, I'm a small landowner with about 80 acres that this will cross. However, I have a Texas Forest Service approved tree farm. Will compensation account for the loss of the timber market value that I will be losing?
We'll advocate for that. Absolutely, because regardless where you are in the state of Texas, for example, in South Texas, you may grow onions. In Lubbock, you may grow cotton. If a crop is taking away from you that is a cash crop, then we believe you should be compensated for that. Native trees, for example, the Supreme Court of Texas says you don't get paid for that 100, 200-year-old oak tree that is on the property, but crop is a different matter, especially when it comes to a cash crop. And I believe timber is a cash crop, and you should be paid for that. So we will definitely we will advocate that for you and come up with a valuation. I hope Entergy has what they have in their methodology, what are called cost to cure items, and for other damages other than devaluation of land. For example, if you have a really nice entryway that is going to be taken out because the transmission line is going to cross that entryway, then you should be paid for what it costs to relocate that entryway. So there's other components called cost of cure and other damages that we absolutely will help you work through to make sure that you get treated as fairly as the law will allow.
Another question we have is the easement is expected to come straight through our only access point to our land. Is that common?
Yes, it's very common that these transmission lines cross entryways, and that's one of the components that we look at for damages is that if it's on the back of the property and you don't see it every day because you enter and exit the particular property, but if you're driving under that line to go to your property and exit your property on a regular basis, we look at that from a market standpoint that a buyer is going to look at that as a negative. So they do span. So remember, we have structures that are going to be placed around anywhere between 800 and 1200 feet apart. And then you have the conductors or the big cables that will go from one tower to the next tower. And oftentimes they use those spanned areas to cross entryways and roads and things like that. So it is common.
Right. Another question. It says, is your fee structured similar to others, being that it's X% over the value that the special commissioner determined? Meaning the special commissioner determined the value of 100 and it is later agreed via settlement or jury that the value is 200. Your fee is a portion or percent of the $100.
We do work on an hourly basis and a contingency fee basis. The contingency fee is generally based on what their initial offer is. For example, if their initial offer is $10,000 and then we are able to obtain $50,000, then our fee is going to be based on that $40,000 difference. And it depends on when you hire us. If you hire us at the beginning, it's going to be based on the initial offer. If you hire us after you have your final offer, then it may be a percentage based above that final offer. Or sometimes we've had clients go to the special commissioners hearing themselves, they get an award, and then we work out a contingency fee based on what that award is. So it really depends on when you hire us, but remember these fee agreements with your attorneys are negotiable. Depending on the size of the property, depending on how big the take is, we will treat every client differently, and the percentages of contingency can vary depending on where you are in the process and the size of the take. So whether it's us or somebody else, standard fees usually are around a third of the difference between the initial offer and what the final compensation is. But experts also have to be hired, and that is something we can discuss about how do we pay the experts and how does that impact our relationship under the fee agreement. So please talk to us. We're happy to work with you. Every property is unique and different. And, as landowner attorneys and as personally as a landowner, I know how important this is and how important this decision is for you. We really value the relationship that we have with our clients, and we're here for you, whether you want to communicate by phone, by email, by text, any combination. I'll also say that if you hire us and you have neighbors, there is some value in having collective groups that are associated with one another in order to negotiate. So I really appreciate that opportunity. And I do want to really emphasize the Texas Land Advocate. This is a newsletter that goes out a couple of times a month. It is one thing that you don't have to be a client. It is valuable information. You can look at it, and Claire can talk more about this, but you may find something that's interesting. If you don't find it interesting, you can delete it. It's not a solicitation letter. It is really a newsletter to inform landowners around the state about what's happening, whether it's at the Texas legislature, whether it's happening about the energy sector. A lot of people have questions about wind farms, wind turbines, AI centers, data centers. What can you do? Easements, things that really affect landowners around the state. So it's really geared to provide you as much information as we can so that you are handling your land and your legacy to the best ability that you can. So thank you.
Thank you all so much for joining us today. If you are interested in subscribing, you can scan the QR code on this slide with your phone to subscribe to the Texas Land Advocate and receive those emails that Patrick was talking about. At the beginning of this presentation, as I mentioned, we'll be sharing the recording and share it with you via email. So if you have anything that you missed or any questions, we'll be connecting you with our team very soon. Thank you.
Thank you, everyone.